My name is Steve Cortes. I've been an attorney for now 25 years. I can't believe it. I remember when I first started and other attorneys getting their 25-year pin, and I guess it's time for me to get mine. When I got out of law school, I really didn't know what I wanted to do, but this was kind of the one area of law that I really enjoyed because I got to build a relationship with my clients. In 2013, I started my own law firm. And I've been doing it ever since, doing estate planning, and we also do probates and trust administration. But obviously, it's a lot easier for the family and for the individual if they do their estate planning ahead of time.
What type of emergency situations do you most often hear from your clients or from people who are calling in and needing help unexpectedly?
Yeah, that's the exact emergency, is that they need help unexpectedly. And a lot of times it's from sons and daughters who call in and said, Mom or Dad is in the hospital. The doctors need somebody to have a healthcare power of attorney in place, or the financial people at the hospital need a financial power of attorney in place, or a guardianship. And so the emergency is they need all of these documents right now, right? And sometimes it is on a Friday afternoon, and we will work with people as much as we can, but I don't want to go to a hospital on the weekends if I don't have to. But sometimes we have to. So that's the biggest emergency, is that people don't plan for their incapacity. And I know this is all about what happens when you go back home, but that's the key. Everybody thinks estate planning is about what happens after you pass away, what happens to your stuff. How do you want to be taken care of right now during your lifetime? That's the most important thing, right? And so you can make all of those decisions ahead of time instead of your family calling me at 4:30 on a Friday saying we need to get something done right now. And even if they're calling me on a Monday or Tuesday, if somebody says the doctors just came in and said Dad has dementia, and the doctor just gave us a note that said he can't sign documents anymore. Well, guess what? We can't do a power of attorney anymore. We can't do a healthcare power of attorney. That ship has sailed. So then we're stuck with guardianship. And guardianships, if we go to a court and want a guardianship hearing, it's usually 20 to 30 days into the future. Well, they need something right now, right? They called us because they need something like this hour, right? They need somebody to be able to make those decisions. And so there is something called an emergency guardianship, but that also means that you're going to have to go to court with me that very day. We're going to have to go to the judge, and we're going to have to prove to a judge that an emergency situation actually exists. And lately, that bar has gotten raised. It used to be, honestly, very easy. We'd go in there and say, there's an emergency. We need to place them someplace. And now the judge is like, well, is that really an emergency? Just the placement, right? And so it could depend on the judge that you get whether or not you're going to get the emergency. If not, you may have to wait 20 to 30 days before somebody will have the authority to even act on your behalf.
So what happens in that situation, Stephen, if you go before the judge for an emergency, or the judge looks at it and says, nope, doesn't look like an emergency to me, but you have a loved one at the hospital who needs to be placed in the hospital saying, your time's up, you have 2 days. You tell them, well, I'm sorry, we can't get guardianship because the judge is not going to see us for 30 days. What happens?
Yeah, honestly, I don't know what happens.
Okay.
That's more maybe your question. Yeah, I mean, if you don't have the authority, you don't have the authority, and that can create a lot of problems for the family, for trying to find a placement. The person may have to end up going home, and that may not be the right place to go. And that may actually exacerbate symptoms and make your situation even worse. Whereas if you just planned ahead, I think this is what you're talking about, if we just planned ahead and put somebody in charge, we wouldn't have to go to the court, we wouldn't have to rely on somebody that your family has never met before. Imagine making life-changing decisions on your behalf that somebody who you've never even met is making those decisions for you.
The person at the hospital or someone who is just checking a box and trying to move you right through the process.
Right. And a judge who you've never met before. And we have some, especially in Oklahoma County, we have some super kind judges, but they also have a job to do and they have a law to follow. And so, You know, it's not just because they're like, we don't feel like it today. It's because there's been recent cases and laws coming down where they have to follow the law. They have to be careful too.
You talked a little about what they don't have. So what are some of the key documents that would help the family and the loved one be prepared, or each of us be prepared if we go into the hospital? What are some of those key documents that we need?
Right, and obviously I advocate for a complete revocable living trust centered estate plan that kind of covers everything, finances, everything. But if we're just talking about health today, you need a health care power of attorney. Okay, and a lot of times there's some good online places, but a lot of times if you go on there to do a power of attorney, it's kind of an all-encompassing power of attorney, your finances and your health care. And I always tell families, you know your kids, you know the people closest to you better than anybody else. And your daughter may be fantastic with money, and your son may be horrible with money, right? That's actually the scenario we see. You give your son $10 and he's going to spend $30, right? So you don't want him in charge of the money. But maybe he's the one who has maybe for healthcare reasons, he's the right person for that role. Maybe it's the daughter for both of them, I don't know. But I really advocate having a financial power of attorney, a healthcare power of attorney, so 2 separate documents, an advance directive or a living will. And that's the one that says, you know, if I'm in a persistent vegetative state, what do you want to happen? Do you want to be on machines, essentially? Do you want to get food? Do you want to get water? Do you want to get pain medication? I'll say that 90% of our clients, 95% of our clients say, I just want pain medication. Just pump me with morphine and let me go, right? I mean, you're brain dead, right? And so we really don't know what happens. And then the next one is HIPAA. Who is in charge, who gets to look at your medical records. So your healthcare power of attorney and your HIPAA are usually the same, but I have found in practice that some places want an actual separate document just for the HIPAA. And so, you know, that's an easy printout.
Didn't that change some during COVID too? And where people had powers of attorney, but then they were saying you had to have HIPAA on top of it.
Right.
And so that's kind of where that double check
Yeah,
came.
right. And that is even more reason why I like to split everything up, right? But again, you know your kids better than anybody else. So pick people, and that's the other important thing, is pick people in these fiduciary roles. That's what we call them, fiduciaries. The people who you implicitly trust to make your healthcare decisions. And don't just, one more point.
No, you're fine.
A lot of families come in, a lot of moms, a lot of dads come into our office and say, well, I don't want to hurt their feelings, so I'm going to put both of them as co. Okay, if you ask all 3 of us the exact same question, we're going to give you 3 different opinions, right?
Maybe not.
Maybe not.
You and I agree.
Right.
Okay, so I think that, let's see, do you think they should?
No.
No, me
Yeah.
neither.
Yeah.
Yeah.
Okay,
Yeah.
so there you go, unanimous.
Yeah, on that point, yeah. I
On
think
that
we're all
point.
unanimous on that point.
And I'm the youngest of 3.
I'm the
Yeah.
oldest of 5.
And I am not my mom's POA.
Yeah,
Let's
oh,
just
well,
say
I
that.
am, but I can tell you right now,
Yeah.
I don't vote for it.
Yeah.
I don't wanna, because when you do and, if you do co's, what does that mean?
Then the medical personnel, they don't know who to talk to, right? And especially if the document isn't written very well, right? Then Sally may walk in and say, I want this to happen. And so they start the procedure. And then Enrique comes in and has the exact same power. Sally went to lunch and he stops the process. And then we've seen it with banks, where banks don't even want to touch a co-financial power of attorney because of that exact question. They don't want the liability, right? Sally comes in and takes mom's money. Enrique comes in and says, don't let Sally take the money. Okay, same thing with healthcare.
What are some of the misconceptions with documents, legal documents, that people have thinking that there's always tomorrow? What are some of the things that they think? I guess the answer is they think they can call you on Friday and get it done.
Right. Well, and they think that they can always get the documents done. Like I said earlier, we'll get a son or a daughter saying, Dad or Mom, the doctor literally just gave us a diagnosis, wrote down that they can't drive anymore and shouldn't be entering into contracts. Can you get us a power of attorney? No, we can't. That, like I said earlier, that ship has passed. But I think also the misconception from a story, a dangerous story point of view is that what we see, unfortunately, exactly what you just said, is that everybody thinks if you're going home, everything's okay. And what we see a lot, unfortunately, is somebody moves into the house thinking, well, I'm going to take care of mom or dad. Or the worst is the neighbor down the street moves in and says, you know, I've been having coffee with your mom for the last 10 years or maybe 6 months, and I just think it'd be better if I lived here. And we're literally now having to evict people from people's houses because these people who are moving in and they're really just taking advantage is kind of the horror stories that we're seeing over and over again lately. And we're seeing that more and more. Like I said earlier, 25 years of doing this, and then 25 years related to probate. Well, just in my entire career, up until this last year and a half, I'd only evicted one person. That's the only, I'd only had gotten one. I know they happen all the time, but this past year, and we've had a bunch, Shannon and I have had a bunch together in the last year and a half, where we are just constantly, it's gotten so bad that I now have an attorney who just does the evictions. We farm them out to them because it takes time out of my day to show up at eviction court to evict Sally because she moved in because she didn't have a job, and so this is her new job. That's the thinking, right? I'm moving in to take care of mom, and so I deserve all of this. And then it just creates problems later on when mom does die, because then Sally's like, well, I took care of mom for the last 3 years. It's all mine. And that goes to the estate planning part, but that's absolutely not true. Just because you took care of somebody doesn't mean you get their stuff. But recently, I mean, within the last 6 months, we had two. One was a neighbor, and they just moved in. They didn't even ask the family. They just moved in. And that got, because now they're tenants, right? Now they're a tenant. And then another one was, we had a niece, I think she was a niece, move in too. And she even, like, I want to say she literally had people come in and build a wall to divide her part of what she thought was hers. So it can get really bad. Can I tell one story about dementia? Because this one happened, I guess, about maybe 6 years ago, maybe 7. But we had somebody who went home, dementia, and should not have been by herself, but that was the easiest solution for the family. And unfortunately, they kept, well, you have to have a phone, right, at your house, and she would always answer the phone. And she was on Social Security. I think at the time she was getting $1,100 a month on Social Security. Somebody finally got her for $19.99 a month for something. I don't know what it was. And once he had her for the $19.99, then he called her back and got her for another $19.99. And then he shared it, I guess, with his other telemarketing fraud friends network. And before we knew it, they were hitting her account. Whatever day her Social Security account was, her Social Security check would come in, let's just say on a Monday. On Tuesday, she was getting hit for $1,200. So every month she had a negative balance. For a while she was okay because she had more money to cover it. But her money just disappeared every month, like literally. She had a mortgage on her house before her family found out. She was already 7 months behind in her mortgage payments. They ended up foreclosing on the house, so she lost the house that she had actually owned for almost 20 years. And so it was just, we had to get a guardianship. Now that wasn't an emergency because we were coming up on the Tuesday, and a judge agreed that if we didn't get a guardianship in place immediately to close down those bank accounts, or her bank account, that her Social Security check was going to be gone again. And then we changed her phone number, but before we did, she got horrible phone calls from all these telemarketers who, like, where's my money?
Yeah, her previous friends.
Right. So that's just a horror story that can happen of somebody who goes home and everybody just thinks that it's going to be okay. Unfortunately, it's probably not going to be okay. You have to have a plan in place.
So there are different documents out there for people with their houses. They can do wills, trusts, And often I will hear people that are in emergency situations and they'll say, it's not a problem, Shannon. If we hit an emergency situation, we're just going to do a transfer upon death deed for my kids and they can have the house. How does that work?
Well, first it goes back to, does the person have capacity to do what they're going to do first, right? So by very definition, if it's an emergency, then they probably don't. And so you cannot do that transfer on death deed anymore. You can't change your bank accounts to pay on death beneficiaries. So the documents that you need to have are, like I talked about earlier, is a good solid estate plan that grows with you as your life changes. So what we recommend a lot is that people get a revocable living trust centered estate plan, have a revocable trust at the center of it, still have a will, but the will catches things that are not in the trust and it pours it back into the trust for distribution under the terms of the trust. Same documents I talked about, your financial power of attorney, healthcare power of attorney, your advance directive called living will, HIPAA authorization, and all of that works together to provide an umbrella of protection around you. Going to the houses specifically, you put the title, so I always talk about Sally and Enrique, I don't know why, but Sally and Enrique are married, and right now their house is Sally and Enrique as joint tenants with right of survivorship, okay? So they think they're safe because if one of them dies, it automatically goes to the other one. But what if both of them die at the same time, or within a short amount of period? Then there's gonna have to be a probate to get it to whoever it's supposed to go to, okay? Next, if you had that property actually titled, instead of just Sally and Enrique, you had it titled as Sally and Enrique trustees of the Sally and Enrique Revocable Living Trust. They get incapacitated, that's what we're talking about here today, right? They become incapacitated, then their trustee just steps into their shoes, okay? You guys are all CEOs of your own lives right now, but if you become incapacitated, like every good business, there has to be a succession plan. So that is what your trust is. You have named your successor while you're alive to take care of you. And when we're talking about real estate in particular, because that property is in your trust, your successor trustee simply steps in your shoes and can sell it as the trustee.
Or maintain it.
Or maintain it, exactly. Pay the insurance, make sure that that Social Security check that you're getting every month goes to what it's supposed to go to, right? Now, don't have anything at all, then we get into an emergency situation and people say, well, we already said we can't do the transfer on death deed, but what if the property has to be sold because you need the money for something, because you're gonna move into wherever and you need that cash? Well, if we have to get a guardianship, then just because somebody is the guardian doesn't mean that they can just sell the property. Once a guardianship is established, everything that happens to your assets, if you're the one somebody has a guardianship over you, everything that happens to your things, your possessions, your real estate, has to get the approval of a judge to sell it.
So really the person who is named the guardian is just a reporter to the courts.
Essentially, right. They can still talk to like healthcare and make those decisions. But if we have to sell property, and it's not just like, I don't want to talk about probates, but if you die, then there's something called, if everybody consents, the property can just be sold very quickly, which we do. We call that a 239. But if not all the heirs agree, then we have to do it by auction. And unfortunately, the laws are written in Oklahoma that if you have a guardianship, that 239, that consent way to sell things is not available. So a property has to go up for an auction. Now, Shannon can still sell it, but she can tell you how frustrating it is. I always tell people it adds another 3 months and about $3,000 to that I'm going to take from their pocket for court costs, for just everything, just to get that house sold. Where if you just had a plan in place, you had a successor CEO set up, then your family wouldn't have to waste that $3,000. $3,000 that could be spent on care, on medicines, on things that you actually need.
So her question is what is a ballpark figure for your process for a trust? What does that look like? What does that cost? What should people expect?
That is a great question. And most people, so I believe it's under, if your assets are under, I think it's $13.9 million right now, then what I'm going to give you a price for pretty much applies to everybody, right?
If
For-
you're above that, if you need an extra daughter, let me know. I have a job, I have a house, and I'm very,
Right.
I'm very used to
and
it.
it's times two, so if you're married, it's actually $26 million, okay? So if you're not in that top zero, and I did the calculations, if you're not in that top 0.5% of the United States that has over that amount, then we have pretty much a trust set up that we use for everybody. Now, we do customize it for everybody, right? Because like you're talking about changes, and that's the other thing is you need to go with your attorney, just like you go to your doctor, your insurance provider. You need to talk to these financial professionals every single year to see where you are. For a single person, we charge $3,150 for that package, and it includes the trust, pour over will, financial power of attorney, healthcare power of attorney, your advance directive, your HIPAA authorization. We also do basically a bill of sale where you're selling everything, your clothes, furniture, appliances to your trust. It just says, going forward, my clothes belong to my trust, okay? And we also do one real estate deed into your trust for you. So for a single person, it's $3,150. For a married couple, it's $3,550, okay? And then we also will help you fund it. That's an additional cost. And right now we're actually working on something that I think people are gonna like, to kind of align all of their assets on a yearly basis with their trust. So in other words, make certain that our clients are actually changing their bank accounts. If they buy another piece of property, if they've downsized, making sure that new place is in the name of the trust, because that's actually the biggest thing we see is, and I know your question was just about price, but one of the biggest things we see is that people will sell their home that they raised their family and downsize, and they don't tell Shannon. They don't tell the title company that they have a trust. And all of a sudden we have to probate that asset when they pass away. So those are our prices, $3,150 and $3,550.
Okay, very good.
Can I ask a tag-along question?
Sure.
Sure.
I think, it's probably more beneficial for me, but what age do you recommend someone
Oh, that's a
starting
good
to
question.
do that?
So the question, y'all heard, what age?
Yeah, what age do I recommend you get a revocable living trust centered package wherever you are in your lifetime? And in fact, today, right? But yeah, I also mean we have a
Kids could.
yes. So we have a lot of young ladies working for us who one of them just had a baby, and that's where we started thinking. She's like, I don't have any of this in place. Like, what happens to us right now, right? If something were to happen to us, who raises our child? Who is going to be in charge of that child's money? Because you can't give a child $100,000 or $50,000, right? So for those situations, I say have your insurance policy, if you're a young couple, pay into your trust, and then have your trustee administer that money for that child for their lifetime, or until they're 21 or 25 or whatever. But the right age for anybody is whatever age you are right now.
Barbara, what question do you have?
Is the HIPAA built into a trust?
No, so it's part of the
Into the health?
healthcare power of attorney, right, and a separate HIPAA document. So we actually do two. We do a healthcare power of attorney and a HIPAA authorization.
So he double dips to make sure it's covered
HIPAA's
completely.
part of the healthcare.
Two separate documents.
Oh, it's two separate.
Right. So the healthcare documents that I recommend everybody has as a base are your healthcare power of attorney, your HIPAA authorization, who can look at your medical records, and then third is your living will or advance directive. Okay.
So that's a good one. Okay, Kathy, what question do you have?
But I've got that set up with my doctor.
Okay, so her statement is she has it set up with her doctor. Well, that's great. But if you have an emergency on the weekend and they don't tap into that doctor, or if you're out of state, or your family wants to know, they're not going to look that up and contact your family for you. The family needs to have that. They won't necessarily connect the dots for you.
Yeah, and let me just follow up on that, because you brought up a really good point about what Tracy said. She said tape all your documents to your wall, and that is absolutely true. I remember when my dad passed away in, I think, 2017. But I remember going home to visit, and my mom had done that exact thing for EMS, because she was calling EMS about once a month for my dad. And so everything was literally taped to the wall. I can't tell you how important that is.
Smart.
And yes, you also, your primary care, your GP probably has that information. What we do is for our clients, we pay for their first year of a service called DocuBank. Is it DocuBank? Right, absolutely. And so what we do is we upload the healthcare power of attorney, the HIPAA authorization, the advance directive. We state, or they put in there, our clients do, what their medical conditions are, what allergies they have, who their emergency contacts are, because if your doctor has it, that's fantastic, and if they're part of a network, then hopefully the network can tap in and look. But if you're on vacation, if I heard you guys talking about a cruise ship earlier, if you're on that cruise ship, then how are they going to know who your emergency contact is, right? And so you carry this little emergency card, and they immediately know, oh, call Sally or Enrique as your emergency contact, right? And then on the back, they can call the number, and they will fax it to the medical personnel, because you can't email medical. That's a violation of HIPAA.
They're the only.
So it depends on how it was written. So her question specifically was, can the HIPAA be wrapped up into the power of attorney? And
advance directive, I have both.
right. So I have seen, in fact, in mine also, my healthcare power of attorney, it also names the exact same people as your HIPAA people. But in practice, what we have seen is that some facilities want a